The IP strategy becomes even more crucial in a fierce competition and long-term crisis business environment. What to do in order to protect a trademark, a patent, or another intellectual property right in France, especially if I feel at risk that a competitor would like to copy-paste my products. The trademarks and patents have to be filed and pending before the French Patent and Trade Office, INPI, whereas copyright and software programs are protected under another scheme. There are some specific steps well summarized on the Institut National de la Propriété Industrielle website in order to protect and then to evidence objective, principally documentary proofs of any counterfeit. Nevertheless, as a preamble, an initial check should always be carried out to ensure that the products at stake are protected under patents, trademark, copyright currently pending in France. In France, the relevant authority to file IP rights is the French Patent and Trade Office, called the INPI, Institut National de la Propriété Industrielle, which allows as well to check priorities on its own databases. In order to evidence a patent counterfeit, one example of a particularly powerful prior step is the requête à fin de saisie contrefaçon, an ex parte counterfeit evidence seize petition, filing for an ex parte petition with the presiding judge of the High District Court, Civil Court, seeking authorization for a bailiff accompanied by a police officer as well as a technical, judicial, industrial expert. Such court order allowing the claimant's bailiff to break in the competitor's business premises with a right to collect evidence of any alleged infringement. The case must thereafter come before the relevant counterfeit specialized courts, à Paris la troisième chambre, with a view to an intra-ex parte hearing, and the defendant may, of course, seek damages if the ex parte steps were not carried out into the prescribed legal manner and if they fail to produce evidence of infringement.